The appeal in the name of the Provincial Commons Authorities and Seiler and Appellant.
Yes, Mr. George.
Hello.
I can tell you that we have read the two decisions of the Upper Tribunal.
I'm enormously grateful, my lord.
And the scouting arguments.
I'm very grateful. I represent the FCA this morning with my learned friends Miss Rooney and Miss Mayer.
Yes.
My learned friend Miss Clark, King's Counsel, appears for the second respondent, and I understand in relation to ground one only, and the first respondent is not represented for reasons the court will have seen in the correspondence. I hope, my lords, my lady, has a core bundle, a supplementary bundle, and a bundle of authority.
Yes.
I'm very grateful. As my lord has seen, this is an appeal against the costs order of the Upper Tribunal. I would, if I may, briefly introduce the shape and nature of the appeal, recognising that my lord has read the judgment below. Ms. Mayer will then briefly introduce the statutory scheme and the principles pursuant to which the tribunal is entitled to award costs, and I will then deal with the two limbs, the two grounds of appeal.
Yeah.
But my lord, if I was to encapsulate the reason we are here, it is that it is right that each of our two grounds of appeal has two limbs effectively set out at paragraph 52.5 of our skeleton argument, which my lord will have read, that is at page 39 of the core bundle.
Can I just remind myself of it?
We have adopted with great respect the categorisation of my Lady Justice Falk in the recent case this year of various eateries and alliances. But effectively the first of our limbs is that the decision which we appeal proceeds principally on and discloses an error of principle. We say that point of principle relates to what the Upper Tribunal have found to be the tribunal's relationship with the regulator, the FCA, what it calls the supervisory jurisdiction, and the nature of the proceedings before it. And if I could encapsulate that for my lord, one could perhaps go to the core bundle at page 107 and the decision refusing permission to appeal of this Upper Tribunal.
107.
107 at tab 6, paragraph 10, it's line 1. In my view, the authority misunderstands the premise of the decision. The basis of the decision was not that the authority was required to exhaust all options to obtain evidence from any person that might reasonably be considered able to give relevant evidence to the tribunal, and the tribunal is there disagreeing with my characterization of their decision. But what the tribunal do accept is their reasoning. The tribunal simply found that the authority had acted unreasonably in all the circumstances, bearing in mind, i.e. treating as a highly relevant consideration, the supervisory nature of the tribunal's jurisdiction and the key differences between proceedings of this kind and normal civil litigation. And for my lords and my ladies' note, in relation to ground 2, if one goes over the page to page 109, paragraph 16, my lords will see at line 2, in my view, it's open to the tribunal to conclude that the authority acted unreasonably in not responding to Mr. Seiler's requests. Again, I emphasise the point that the tribunal has a supervisory jurisdiction in relation to references of this kind, which makes the position different to normal civil litigation. Now, I will obviously have to persuade my lord that there is an error of principle that has been adumbrated in these decisions by the tribunal. But in my respectful submission, it is clear that that is a highly relevant consideration and indeed basis for the decisions which we appeal.
But you call it an error of principle. You are restricted, of course, on this appeal to questions of law.
My lord, yes.
So you say it's wrong in law.
My lord, we do. We do. We say it is a principled, it is a legal error in that it is not the case. I can't say, and I don't say, there are no differences between these tribunal proceedings or civil litigation. But the differences they have identified, which I will take you to as I develop the appeal and the decisions, in our submission are wrong in law. They are not a correct application of the two analogies which this tribunal relied upon, which I will address my lords and lady on. The first being an analogy with the duty of candour in relation to judicial review proceedings, and the second being the statutory provision, section 133 of FISMA. And I will address you in relation to both of those. But we do say it is wrong in principle, and from that was wrong in law, and from that legal error flows the error to find that these decisions were unreasonable. And whilst again,
So do you say then that it's an incorrect description, that it's a supervisory jurisdiction?
my lord, in some respects, that would not be an unacceptable description, if I can put it that way, when one looks at
In some respects, that would not be unacceptable. In other words, it can be accurate.
It can be accurate, but not when I show, my lord, in my respectful submission, the way it is used in the decision, the reasoning, as it were, as to what they are meaning by that phrase, in my submission is not accurate, it's not right. And my lord, whilst clearly this is a question of law that my lords are considering, my lady is considering, the FCA is here because it does make a massive difference to the way in which it is able to fulfil its statutory objectives as to whether or not the tribunal is right in the width it requires the authority to conduct its investigations.
The width that the tribunal requires is, at first blush at least, a question of fact, not law. So you say that the tribunal was wrong in law in describing its own jurisdiction as being supervisory. What is its jurisdiction then?
Its jurisdiction, and I will primarily say it is the same as that of the civil litigation courts. It is finding and determining all issues of fact and law. It is deciding whether the authority's case, which is brought before the tribunal, is made out on the evidence on which the tribunal seeks to rely, taking into account, as any civil judge would do, any adverse inferences it draws, the evidence tendered by the other side. But that is its jurisdiction. It is not, and I will develop this, a court of judicial review. And fundamentally, it is wrong in our submission to say, as this tribunal has, the tribunal is akin to a court of judicial review, and therefore the authority is required effectively to tender before it witnesses on which it does not rely, witnesses it does not consider are statements of truth, and you'll see ground 2 relates to requests for further information about the same point, effectively to conduct and bring before the tribunal the types of evidence one might have in, for example, a public inquiry. We say the true analogy is with civil litigation and the principles that are applied there. It does not go wider than that. But I do not say in any way that means that we are not required, as every public authority is, to be honest with the authority. We cannot tell them, with the tribunal, we cannot tell them half-truths, we cannot mislead them. Of course there is a duty of candour to that extent. To encapsulate this appeal in one fundamental proposition would be this. The tribunal has erred in taking principles applicable to the duty of candour, the way in which a public authority describes the facts within its own knowledge, the way it has conducted itself, the basis for decisions it has taken, all of those very familiar elements of the duty of candour. And the tribunal has expanded that duty to encompass bringing before the tribunal third-party witnesses over whom it has no control, who it may well not have investigated or interviewed, certainly isn't relying on or seeking to rely for this decision, and saying that those third-party witnesses must be brought before the tribunal because that is part of the duty to put all relevant facts before it. If that is right, it clearly has a very significant implication for the way the FCA is able to conduct its investigations and what it does. We say it is wrong. Either way, it is important in our respectful submission that the position is looked at. And my lord, the second limb of my grounds of appeal is a much, it does not give rise to that type of question of law. We say it is unreasonable, irrational, if I put it that way, on the traditional test for the findings which have been made in the light of this case. But my lord, may I, before going into the reasoning of the tribunal on duty of candour, just say something about the case below. So my lord has the shape of the debate and the type of the case below, recognising that my lord has very kindly read the very lengthy decision at first instance, for which we're grateful. The FCA's case below was that the two respondents, Mr. Seiler, the first respondent, and Mrs. Whitestone, the second respondent, acted recklessly in that they were aware of various red flags, as they are often termed, indicating that a fraud may be being committed by the client of the bank they worked for. And they were therefore subjectively aware of a risk that fraud may be occurring. Two limbs, effectively. Here are the red flags. This is what we say they objectively show. And then secondly, because this is the legal test for recklessness, you must have been subjectively aware of those risks. And to show that, my lord, that is the essence and the entirety of the case, if one goes to page 76 of the core bundle and paragraph 6 of the costs decision, my lord sees in line 4, in essence, the authority's case against the applicants was that they lacked integrity on the sole ground that they disregarded risks of which they were actually aware, that Julius Baer might be facilitating or participating in financial crime by participating in the arrangements with Mr. Merrison. And my lord will have seen from the decision, there was no dispute and never was that there was an underlying fraud committed by the clients. And the tribunal have found that the objective evidence which we said were red flags were indeed red flags, and that a reasonably competent person would have identified the risks to which we said they gave rise.
I mean, the essence of the tribunal's substantive decision was that the two respondents to this appeal were naive but not dishonest.
Precisely. And I do put it further, incompetent but not dishonest. And I don't say that for forensic reasons, but simply the objective points we made as to the nature of the red flags were accepted. What we lost on, and I accept, therefore lost entirely, and I don't in any way resolve from that, was did these respondents subjectively appreciate them? And I'll just show my lord just the two passages, and only two passages, just so my lord, if I may, reminds them of them. So one sees in the cost decision, just going on to paragraph 12. This is the tribunal's obviously own summary of the decision. In relation to Mrs. Whitestone, the tribunal concluded that the relevant risks would have raised suspicions in the mind of a reasonably competent relationship manager, but they did not raise suspicions with Mrs. Whitestone. And then going on to paragraph 13, which is over the page at page 78, they actually quote from their own decision at paragraph 85.4, though the indented part, those findings indicate that Mr. Seiler did not exercise due skill, care and diligence in considering the proposals before making his recommendation to Mr. Wrightson that the arrangements be approved. And there are many other references which my lord has seen. That is the nub of the decision. They lacked competence and capability. They did not lack integrity because of the subjective matter. And the key point as I develop our grounds of appeal is this, that this was a case brought within a narrow compass in terms of the evidential allegations. We said, these are the matters, these are the red flags. This is the objective evidence we say you were aware of. That has been proven. We say this is the objective evidence, what it gave rise to in terms of what a reasonable person would have thought, and that we were successful on. We then said you subjectively appreciated those risks and that we lost on. And that is a fairly common type of allegation in regulatory proceedings. This would have been obvious to a reasonable person. You're reasonable, you're experienced, it must have been obvious to you. You can win those cases or lose those cases. But my point for today's appeal, in my respectful submission, is that a public authority is entitled to and can advance such a case within that evidential compass. This is what we rely on as what you knew. We say you must have known and did know. We say it cannot be a mandatory requirement, recognizing, of course, that I'm going to have to develop this by showing you the tribunal's reasoning and why I say this is what they've done, but it cannot be a mandatory requirement that in order to bring such a case, the authority is required to interview and then call as witnesses anyone who might have known about or received some of the red flags, and then form a view as to whether those people appreciated the red flags, or didn't appreciate the red flags, or themselves lacked integrity but aren't within the category of people who the regulator has chosen to bring proceedings against. To do that effectively is a multiplicity of what the FCA would be required to do. And going back to my original analogy with civil litigation, and my respectful submission is plainly not necessary if the tribunal's jurisdiction is to decide as a matter of fact, law where it arises, what are these red flags? Did he receive them? What do they objectively show? And what was in his mind? And my lord will have seen the two grounds have separate aspects of that theme. Ground 2 relates to a request for further information about what people knew, when the authority didn't know what they knew and couldn't provide that answer. Wasn't part of their case, they weren't relying on them. And then relatedly, by the time we get to trial in ground 1, the witnesses who it is said that we should call. And my lord, I make one more point before leaving this cost decision and turning to the statutory jurisdiction. And that is to look at the tribunal's reasoning when they were asked the question, was it reasonable to bring these proceedings at all in these circumstances? They knew what we were relying on. They knew who we hadn't called. They knew who we hadn't investigated. And they summarised that at paragraph 71 of the costs decision, and that's at page 91. So the tribunal say this: accordingly, the documentary evidence that the RDC was faced with, which was essentially the same as that before the tribunal, was that a highly experienced senior manager, this is Mr. Seiler dealing with here, failed to notice obvious signs of the suspicious activity on the part of Mr. Merenstead and Mr. Feldman. So when the authority decided to bring these proceedings, they had evidence that there were obvious signs of suspicion. Paragraph 72, the tribunal find it is, as Mr. George submitted, most unusual for a person of Mr. Seiler's experience and seniority to have failed in that way. In those circumstances, it was not unreasonable for the RDC to take the position, as it clearly stated in the decision notice, that Mr. Seiler must have been aware of the relevant risks. So for what was at the principal costs application, which was it reasonable to bring these proceedings at all, the tribunal have accepted there was a reasonable case to bring on this narrow basis. This is what Mr. Seiler knew. These are the risks we say it gave rise to. Mr. Seiler subjectively had this awareness. The tribunal have found that that was reasonable. That's why this is a 5% costs order, not a 100% costs order. But they have then found that we were unreasonable within the principles and the regime not to have provided information about the subjective knowledge of, and I will take my lord through them in due course, but a significant number of people about whose knowledge we had no case and didn't rely and couldn't answer, we didn't know, and to call a number of witnesses, again, on whom we didn't rely for the purposes of that case. And we do say, as a starting point, it is a surprising position that it can be reasonable to bring a case on the basis of what Mr. Seiler knew and then saying, well, this gives rise to obvious risks. You must have known that. But whilst accepting that was reasonable, to then hold that we have this duty to effectively put before the tribunal lots of evidence and lots of information on which we don't rely in order to seek to establish that case. Now, my lord, I will, with your permission, ask Mr. Mayor just to introduce the statutory test on unreasonableness, and I will then address you before going through the specific ground on that analogy, on the error of law, on the duty of candour, which I appreciate is at the heart of what this court is being asked to look at.
I'm bound to say I didn't get that impression from the grounds of appeal or the skeleton argument. This was the heart of the appeal.
My lord,
it's not mentioned in the grounds of appeal themselves. The skeleton argument was really dealt with at paragraph 51, where you say, in relation to the supervisory nature of the tribunal's jurisdiction, and the key difference is, you don't say that that statement is wrong in itself. 51.2, you pick up the tribunal's observation that cases are similar to judicial reviews. And a few lines further on, you say the proposition, even if correct, is not justified. You don't say it's completely wrong.
My lord, and I don't seek to elevate.
So this is certainly the appeal has different emphasis from what I had gathered from reading the grounds of appeal in the skeleton.
Well, my lord, I don't wish to have put myself higher than I'm going to be able to be when I address, because what I wish to say to you is effectively that which is at 51.2 and 51.3 of my skeleton argument. And it's simply this: I'm not attacking the idea that there is a duty of candour within the bounds that has always been established in relation to a public authority. It's this overlap, this read across to third-party witnesses in a trial, and that point is made at 51 and following. And this is not a wholesale attack on anything more than that. And in a sense, I'm responding to make sure that it's clear the limits of what I'm saying, as much as to emphasise these points. But my Lord's point is entirely accepted, but just as a matter of structure, I will deal with it after Ms. Mayor, subject to anything my Lord says.
Right. All right, Ms. Mayor.
My lords, my lady, you will have seen from the parties' skeleton arguments that there is little dispute between the parties as to the statutory scheme. The short point is that a restrictive cost regime applies. Costs may only be awarded against the authority where it has acted unreasonably, either in its conduct of the proceedings or in its original decision.
Yes.
That forms the case of the reference. Now, the statutory power of the Upper Tribunal to make an award for costs is contained in section 29 of the Tribunal's Courts and Enforcement Act 2007, and you will find a copy of that at tab 2 of the authority's bundle.
Yeah. Yes, I mean, I think you'll find that we're relatively familiar with the restrictions that apply to the Upper Tribunal in ordering costs, and indeed the tribunal judge in this case set them out. And I don't think there's any criticism of his exposition of the principles on which he was required to act.
That's entirely correct, my lord. So very briefly, section 29, that's the statutory basis. Costs are in the discretion of the tribunal, under subsection 1. That's subject to the rules. Those rules are Rule 10, which is behind tab 3, and on page 22 there are the two limbs, limb D and E, and that refers to the conduct of proceedings and the original decision making, as I referred to earlier. And the threshold condition there is unreasonable conduct. If it may assist your lordships and your lady, I would propose to briefly take you through the two key authorities on what unreasonableness means in that context, at least in the financial services cases. And those cases are FSE and Marcoux. The first of those cases, FSE, is behind Authorities tab 14. And just 3 short points from that case, by picking it up on paragraph 25, which is at page 200.
Sorry, bear with me, the rings on this binder are broken. Right, so this is Financial Solutions and FCA.
That's right, my lord. So, paragraph 25 on page 200, here is a summary of the key principles that apply to the tribunal's cost jurisdiction. And we see paragraph 25, subparagraph 1. The rule is a threshold condition. It's only if the tribunal has concluded that there has been unreasonable conduct that the jurisdiction to award costs arises. And a determination of the question of whether a party has or has not acted unreasonably, accordingly not a matter of discretion, but a matter of value judgment. The question is whether there was or was not unreasonable conduct. What is helpful from this authority, in my respectful submission, is the examples that the tribunal then gives as to the types of conduct that qualify as unreasonable. And we see in subparagraph 2, picking it up on line 3, where an appellant has unreasonably brought an appeal which he should know could not succeed, where a respondent has unreasonably resisted an obviously unmeritorious appeal, or where either party has persistently failed to comply with rules and directions to the prejudice of the other side. Similarly, a further example given over the page on paragraph 28 by reference to an earlier case. In that case, it was unreasonable where the respondent, considering the matter dispassionately and by reference to the information available to the respondent, that the review decision was so flawed that it could not be properly defended. Paragraph 29, that formulation is approved. And at the end of paragraph 29, on the top of page 202, the tribunal gives another example where a party could be held to have acted unreasonably, where it fails to produce evidence to support its case. So whilst it's clear that a high threshold applies in my submission from these examples, it's also important to note that the tribunal in this case did make clear that it's not a when there's irrationality standard. It is something beneath that, but there is nonetheless a high threshold that applies when assessing unreasonableness.
But in the decision under appeal, the Upper Tribunal judge set out these principles at paragraphs 46. Paragraph 46. Is there anything wrong with the way he set them out there?
Nothing wrong, my lord. We don't dispute how he summarised those
Right.
principles.
So he's correctly directed himself on his cost jurisdiction.
He adopted the correct test,
Yes.
as set out in these authorities in terms of what unreasonable misconduct requires. But we say he applied it incorrectly because the threshold is high and the conduct he identified as unreasonable was not unreasonable on the proper test.
Well, if he got the law right on costs, as I think you say he did, but didn't apply it, is that an error of law or an error of fact?
An error of law, my lord. He summarised the principles. I mean, perhaps it's worth taking up briefly his decision
Yes.
at paragraph 42, where he does.
Just before we do that, can I just observe he's the same judge who wrote this judgment, isn't it?
That's right, my lord, yes.
These were his principles which he set down in FSE, which you accept to correct.
Entirely
And then
correct.
he correctly recited them again in his subsequent judgment, the one that's under appeal.
That's right, my lord. And he, the point is he does refer to the correct principles, and we don't dispute that that is the threshold for us. But what my submission is that the threshold is a high one,
Yes.
and that it was in the court below applied incorrectly for the reasons that Mr. George will address you on. So just to summarise, my lord and my lady, the point is that conduct cannot be described as unreasonable simply because it leads in the event to an unsuccessful outcome,
No.
or that a more cautious legal representative might have adopted a different course. The question is whether the conduct permits of a reasonable explanation, and that is in our submission the correct test. Unless I can assist you further, those are my submissions on that point.
Yes.
So, my lords, my lady, I took you to the tribunal decision showing that these decisions were taken bearing in mind the supervisory nature of the tribunal's jurisdiction and the key differences between proceedings of this kind and normal civil litigation. And those are principles which the tribunal has set out in more detail, adumbrated at paragraph 96 of the main decision, which I'm afraid is in the authorities bundle, tab 18, page 417. This is the principle, the legal analysis, which underpins that assessment. It's right at the bottom of page 417, paragraph 96. In Frensham and FCA, which we will look at, the tribunal refers to the fact that regulatory proceedings, particularly those whereas in this case, the tribunal exercises a supervisory rather than a full merits jurisdiction, have significant differences from civil litigation. And my lord will then see the two passages set out, and in particular, we draw attention and have challenged in our skeleton argument that at paragraph 89, which sets out the statutory regime, which we'll look at in a second, but then says this: consequently, the tribunal's proceedings in such cases are very similar in character to judicial review proceedings. It is well established in such proceedings that a duty of candour on the part of a public authority is expected, it having been recognised that in such circumstances a public authority is not engaged in ordinary litigation, but in a common enterprise with the court to fulfil the public interest in upholding the rule of law. That means that the authority should assist the tribunal with full and accurate explanations of all the facts which are relevant to the issues which the tribunal must decide. Now, my lord, we make two observations in relation to that by way of criticism, but also highlight a number of parts we entirely accept. But we say the tribunal's proceedings are not, in any fair characterization, very similar to judicial review proceedings, because proceedings before the tribunal involve a full factual assessment, effectively a de novo hearing of the factual evidence before the tribunal, leading to the tribunal making findings of fact on that basis. That is very different to a judicial review proceedings, where there is normally no disclosure, and on that basis a duty of candour arises.
JR is principally concerned with process rather than
Precisely.
underlying merits.
Why did you decide what you decided? What did you take into account when you decided what you decided? What didn't you take into account when you decided? That is exactly why the courts of the administrative court are reliant on the public authority explaining in full that decision process. That is the duty of candour.
And also, because I think the exception of age assessment judicial reviews, the administrative court does not make findings of fact. It doesn't hear live evidence and make findings of fact on that evidence, contrast the position of the Upper Tribunal in this case.
Precisely, my lady. And with my respects, in every case. This wasn't an exception. In every case, the tribunal is starting from scratch. There is no presumption that the authority has got it right in terms of its factual assessment. No weight is given to the fact that the authority has reached these conclusions. That's the whole basis of the regime. Just like a trial in civil litigation, both parties call the evidence they wish to rely on. One party, always the authority in our tribunal, has the burden of proof. So we do not say that we don't have a duty of candour in the sense that where we are explaining what we have done or the way we have done disclosure, then of course we have the same duties any public authority would have explaining matters to a court. But what that duty is being applied to here, for in my submission the first time certainly that we're aware of, is a duty to bring third-party witnesses of fact before a fact-finding tribunal in circumstances where the authority says, rightly or wrongly, but the case that the authority is asking the tribunal to evaluate is, this is the evidence on which we rely, and as I've explained it, it's what Mr. Seiler knew and what we say he therefore was subjectively aware of. And we don't rely on any of this extra evidence, and yet it is being said we have a duty, as part of a duty of candour, to tender these witnesses and to investigate these people. And again, it's that phrase, this means the authority should assist the tribunal with full and accurate explanations of all the facts which are relevant to the issues which the tribunal must decide. Yes, of course, when we're explaining what the authority did or what the authority's internal processes were, but all the facts which are relevant to the issues which the tribunal must decide does not, in our respectful submission, encompass evidence from third-party witnesses upon whom the authority doesn't rely, and nobody else has sought to call. As I say, that turns it into an inquiry, not effectively the type of fact-finding tribunal which we say this institution is.
And after all, if there is an analogy with the administrative court hearing an application for judicial review, the administrative court won't require a public authority to have done more than to fulfil its tame-side duty, that is, to have taken reasonable steps to investigate before making its decision.
My lord, yeah. My lady, yes. And in a sense, this goes further because we are being required, whether we've investigated or not, to sort of tender these people as factual witnesses.
Well, Mr. George, you keep saying that. Your submission seems to be that because these witnesses weren't tendered, the Upper Tribunal concluded that the authority had acted unreasonably. I read the decision rather differently.
I understand, my lord, and I will address you when I deal with the facts on what I might call the directions point, which is what is...
It's not only the directions point, is it? There's the non-disclosure that two of the witnesses have been contacted by the authority, had declined to provide witness statements. The tribunal wasn't told about that.
Well, my lord, there we will, I will take you through the decision, but in my submission, whilst the tribunal were very unhappy with the non-disclosure, that is not the basis of their decision. The basis of their decision is it having been disclosed to them what had occurred was utterly feeble. And I'll take it, my lord.
That is part of it, and I'm sure we'll come on to it.
We will, my lord, but yes, it's,
But if you're saying that the conclusion as to unreasonableness rested on a simple non-tendering of witnesses for cross-examination, well, you're going to have to take us to those passages.
Precisely, and that would be wrong because, not least for ground 2, we can see there's a request for further information. But I will come on to that. But the broad principle which I seek to highlight remains that which I have set forward. It is, we say, enough. And for this purpose, where I'm simply looking at the legal analysis, there is no assistance. It is wrong to draw this analogy with the duty of candour where one is looking at third-party witnesses for a full fact-finding tribunal. And my lord, we have put...
So the duty of candour is no more than to explain the way in which you've made the decision.
Precisely, my lady. And it really exists because there is no disclosure in judicial review proceedings as a matter of course. And may I, my lady, just to follow up that question, in the Authorities Bundle, tab 20, at page 610, there's a very recent decision of this year of my Lord Mr. Justice Fordham in the Police Superintendents Association and PRRB, in which he sets out a series of 10 constituent parts of the duty of candour. And in my respectful submission, there is nothing in here, which is an extremely extensive setting out of those principles, which would give any support that they are of assistance in deciding which witnesses should be tendered or approached for letters of request. And I won't take the panel through it because in a sense my point is one of omission. And my lady has summarised it in my respectful submission entirely correctly, that it is nothing more than a particular application of a particular principle in administrative court circumstances, which doesn't apply where you have full disclosure and third-party witnesses on a fact-finding basis. I note to the court there has been a decision of this court subsequently to all of the documents in this case in relation to the redaction of names by the government, which has also engaged the duty of candour. I have copies if it would assist, but in my submission...
Speaks weekly law reports, I think.
Precisely. It doesn't... There's nothing in that discussion of the duty of candour which takes matters any further, but the court is familiar with it. It has caused quite an amount of comment. But I entirely adopt, with respect, my lady's point. And we have cited, I don't think we need to turn it up, but the ex parte fired case in our skeleton argument. On an application for judicial review, there is usually no discovery, because discovery should be unnecessary, because it is the obligation of the respondent public body in its evidence to make frank disclosure to the court of the decision-making process. And that obviously, this isn't about process, it's about fact-finding. There is disclosure within the tribunal proceedings. Now, I made the submission, which I would now wish to make good, that this is the first time this extension has occurred. And to do that, one needs to look at Frensham itself, which is at tab 17, page 352 of the Authorities Bundle. My lord, my lady may recall that 2 paragraphs from Frensham were cited in the main judgment, and I took the court through them a few moments ago. But it's illustrative to see what Frensham was actually dealing with. Because that was not dealing, and these principles were not in the case of Frensham, applies to third-party witnesses who effectively were the actors in the underlying factual dispute under consideration. What was being considered in Frensham were authority-employed witnesses seeking to explain the authority's policy. It's not something relevant in this case. There was no such evidence. The fraud was clear. But what you'll see in paragraph 75, the 2 relevant witnesses are for the authority aimer's cousins, who's a manager in a department of the subdivision, and a Mr. David Blunt. again, an employee within one of our divisions for supervision. They filed the witness statements. And you can see from paragraph 78 what the concern of the tribunal was. Miss Cousins was therefore not the appropriate person to come to the tribunal to give evidence on such non-routine matters. She was on career leave. Paragraph 80, it has therefore not been helpful that we have not heard from those who made the relevant supervisory decisions or those who were responsible for the development of the authority's policy regarding non-financial misconduct not related to the performance of the individual's role in financial services, or at the very least for Miss Cousins to have ascertained the position. And at paragraph 87, we regarded as unsatisfactory that the authority did not put forward appropriate witnesses and that those witnesses who did attend were not properly prepared. And then you'll see paragraphs 88 and 89, which are cited in the main decision in our case. So, my lord, this reference to the duty of candour and the judicial review analogy came into being in the case of Frensham by consideration of evidence given by employees of the FCA about what their thinking was, what their policy was in relation to the matters under consideration. This was the first case to reach the tribunal of what is often called non-financial misconduct. It involved a conviction for a sexual offence, but not in the context of financial services, and that's why the policy and the thinking of the FCA was regarded as useful. But on any view, in my respectful submission, the analogy with judicial review and the duty of candour is much clearer and closer when one is dealing with the authority's witnesses, because that is a public authority person. It has that analogy. And that is why, my lord, and I apologise if I put it too high.
When you say the authority's witnesses, do you mean that, or
I
do you mean the
apologise.
authority?
Witnesses who are employed.
That's what I was going
by
to
the
say.
precise
FCA
program.
employees.
Precisely.
But
Authority
also, the
employees.
analogy is closer, sorry to interrupt, when what is at issue is the development of the policy of the FCA, as
Precisely.
opposed to factual questions about what people did or didn't know.
Precisely, my lady. And that is why this is not a wholesale attack on all of the jurisprudence of the tribunal over the last few years, because it is only in our case that this duty of candour, the analogy with judicial review, has sought to be applied to third-party witnesses. And, my lord, that is what we say is legally wrong. And my lord, the final point or material to look at in this context.
So just to get this, see if I've got this in my own mind. Where the question is, how did the authority come to formulate and or apply the policy that it did? The analogy with judicial review may be appropriate, but where the tribunal is concerned with finding facts which took place outside the authority's purview, then the analogy with judicial review is inappropriate.
Precisely.
What is wrong in
Is
law.
wrong in law. And particularly the analogy with the duty of candour. It's that idea that when you put forward evidence, you have to put forward everything relevant, which cannot be right when it comes to third-party witnesses to a fact-finding tribunal in circumstances where their job is to decide whether the evidence on which you rely and the case you bring is made out.
Would there be a duty on the FCA to at least disclose exculpatory facts?
Well, my lord, there's disclosure, so yes, I mean, because this is all going to be external, we would have to disclose, and we do disclose, any information that we have that is required, it's the same as civil disclosure. It might undermine our case or reasonably advance the case against us. So we have documents, and that includes transcripts, and that includes any material within the wider range, that will be disclosed. It is just like civil litigation in that regard.
And that's a point that further undermines the judicial review analogy in a case like this.
Precisely, my lady, my respectful submission. Now, the final matter in terms of the material is and particularly to address the question of, well, is this a supervisory jurisdiction, which my lord asked me. And that, for that, if we go to tab 1 of the authorities bundle and tab 11, originally, when this regime was set up in 2001, the tribunal had a complete and full jurisdiction, if I put it that way, in that when a matter went to the Upper Tribunal, originally called the Financial Services and Markets Tribunal, they would hear the case de novo, hear the evidence both parties wished to bring, and would then reach its decision as to what the right result was. And the FCA then just had to do what the tribunal had decided. That might be it was going to prohibit somebody, it might be it was going to fine somebody. It is a full jurisdiction. And this was my unsatisfactory answer, I appreciate, to my lord's question, but you could call that supervisory, I suppose, in the sense that you stand over the authority and you have the final word. I accept that. But it's not supervisory in the sense of managing it or telling the authority how to investigate matters or what it requires to bring. Now, the change to that regime, which you'll have seen reference to, is at page 11 here. So you'll see subparagraph 5, in the case of subparagraph 5, we're in FISMA and we're at section 133.
Yeah.
In the case of a disciplinary reference or a reference under section 39311, the tribunal must determine what, if any, is the appropriate action for the decision maker to take in relation to the matter, and then it remits the matter to the decision maker with such directions, if any, as the tribunal considers appropriate for giving effect to its determination. So that's the original full reference. The tribunal decides what the authority should do and tells the authority what to do. And this disciplinary reference will often, not always, because there are many different situations within FISMA, but will often involve a fine. There'll be misconduct and somebody is fined. The tribunal will decide what level of fine is appropriate if they agree that misconduct has occurred. The one change that was made is there at subsection 6. In any other case, the tribunal must determine the reference or appeal by either dismissing it or remitting the matter to the decision maker with a direction to reconsider and reach a decision in accordance with the findings of the tribunal. And the important point is, what are those findings? At 6A, the findings mentioned above are limited to findings as to issues of fact or law, and then you'll see others, matters to be taken into account, procedural steps set out there. But the main point in my submission is that issues of fact and law, and particularly for today's purposes, fact, remain entirely within the purview of the tribunal. They determined them, and once they have determined them, the authority is bound by them. If the court is interested in what, in practical terms, this subsection adds, it is this, that the tribunal no longer decides whether somebody should be prohibited, in other contexts called struck off effectively. That's no longer for the tribunal to decide. That is remitted to the authority to take that decision, but in accordance with the factual findings made by the tribunal. So, my lord, in my respect, that is not, and I appreciate the nomenclature may not be determinative, a supervisory jurisdiction in the sense in which the administrative court is sometimes described as such, in that it doesn't make factual findings, but effectively supervises the process in which the government or the public body does make those decisions. This tribunal makes binding findings on all matters of fact. And so, in my respectful submission, the way that the tribunal has approached these in law, in taking into account what it describes as the differences between these proceedings in the tribunal and civil litigation, are incorrect. I appreciate I now have to show you that they applied them wrongly and applied them in a material sense, that it makes a difference. But in my submission, that is the error, the legal error that one sees at the start of this reasoning. And I emphasise, my lord, my lady, in relation to civil procedures, the Upper Tribunal rules, and my lord has said, very familiar with how these work, they are In my respectful submission, they look like civil litigation.
Well, they're a bit hybrid, aren't they?
They
I
are
mean,
in
if you
some
bring
respects.
a case before the court, it's either going to dismiss the case or it's going to grant the
Yes.
claimant some sort of relief. It's not going to send it back to somebody else to make the decision.
My lord, that is right, and I have shown the one area in which that hybrid angle has come in, but it hasn't taken away the factual finding nature of this tribunal. And to give examples, I could hand up the rules that would assist, but the tribunal's familiar with them. Under Schedule 3 Rule 4, the Upper Tribunal, we are required, these proceedings start, once somebody has chosen to refer it, with a statement of case served by the authority setting out all facts and matters on which we rely. It's a pleading, as any civil judge would understand it. It's responded to by the applicants. Again, as you would expect, they must set out exactly what their case is. The standard directions for factual witnesses before this case, the one from this case, entirely uncontroversial, shall exchange side witness statements containing the evidence of any witness of fact they wish to call to give evidence at the hearing of the reference, exactly the same as you have in civil litigation. And the tribunal's case management powers set out in the rules provide orders for, just as relevant to today's purposes, imposing a requirement to provide further information and disclosure. The rules also contain, as I have submitted earlier, the standard disclosure regime that we must disclose documents on which we rely, which undermine the case advanced to the opponents. All extremely familiar to any form of civil litigation, because fundamentally the exercise when we get to the tribunal is for the tribunal to evaluate the parties' cases on its pleadings and decide if the tribunal, if the authority has established or satisfied its burden of proof in relation to the case which it has chosen to bring.
So are you saying that the tribunal was wrong in law in saying that it had some sort of inquisitorial function?
My lord, yes, in the sense that, and it's the same point as supervisory jurisdiction, I accept that any court in a sense can have an inquisitorial function. There have been cases where this court, in civil litigation, and a tribunal certainly could, can call its own witnesses if it considers that an exceptional circumstance it is necessary. Clearly, and we see it in civil litigation, particularly with litigants in person, this court does, in the process of testing evidence, it's not simply sitting there letting the parties fight it out. Of course it isn't. So I don't for a moment say it's not inquisitorial in the sense that it has a legitimate interest in that type of activity. But it is wrong in my submission to characterise as inquisitorial in that there is anything that goes beyond what one might see in civil litigation. Party has brought a case. This is the evidence on which it relies. This is what the other side relies upon. You are charged with finding the facts, finding the law, and in some cases deciding what should happen. That is not fundamentally an inquisitorial system. And again, this is I accept, my lord, a submission by omission, in that I'm simply pointing out a negative, but there is nothing in my submission in the rules, in the statutory regime, that either the Upper Tribunal rules or the special schedule for financial services cases, which supports the idea that this is an inquisitorial jurisdiction. The one matter which I draw to your attention, because it is right I do so, is it does have express power to summon its own witnesses. As I say, the court has done that in civil litigation, but it's there. But there is nothing else, I don't think there's anything else relied on against me to support this very wide-ranging idea of an inquisitorial jurisdiction.
So if the court has the power, the tribunal has the power to summon its own witnesses, what other powers do you say it ought to have, but it doesn't, if it was to have the function that my Lord Justice Lewison asked you about?
Well, in my respectful submission, it may not be a question of power, because, I mean, this court obviously has an inherent jurisdiction. That doesn't turn it into a inquisitorial function. But it would have been possible, and in my submission one would expect, for the rules to set out that the function of the tribunal is not just to consider the all facts and matters that the authority relies on, or the similar wording in respect to what the applicant relies on, but to investigate all relevant facts and matters connected with the issue in dispute, in relation to which it could have been provided with its own its own powers to, as I say, maybe it falls within the inherent jurisdiction, I accept that, but more express powers to appoint counsel to conduct their own inquiries, counsel to assist it in relation to examining witness, hearings to set the parameters of any issues which it wished to describe. My Lord, it is in my submission inconsistent with the sort of pleadings regime.
I'm so sorry,
I
can I just
propose.
ask a question? Are you, I just want to be clear, are you saying that the Upper Tribunal does or doesn't have an inherent jurisdiction?
My Lord, my Lady, it does not.
Right.
It does not.
No, because it's a statutory
Precisely,
body, so it
precisely.
only has the powers that are conferred by the legislative regime.
Precisely, my Lady. Yes. So, with the court's permission, I will now turn to look at the decision and the documents that underlie it, having, I hoped, explained where we say the analysis, the point of law, lies. And if I may, I'll start with ground 2, because chronologically that comes first, in that that results from a request for clarification, request for further information, as the CPR would have called it, at the pre-trial stage. But in a sense, the points that arise are the same. And there should be, in the supplementary bundle at tab 1, page 1, the relevant request and our response. So, my Lord sees at supplementary tab 1, page 1, I'm very grateful, page 3, the first of a number of questions. I don't need to read out them all because the structure is the same and the criticism of the judge is the same. But we have a statement of case, which you don't need to go through, but in various paragraphs there are various points of knowledge relied upon as to a red flag Mr. Seiler knew. And in respect of a number of those paragraphs, the question is asked, so you'll see this is a request in relation to paragraph 10.2. It is alleged that when Mr. Seiler approved of Julius Baer entering to find his arrangement with Mr. Merenson, Mr. Seiler was aware of the relevant risks. And what is said is that a question is asked in relation to another individual called Caroline Thompson-Beelman. And you'll see it is said that 2 of the red flags on which we relied were matters of which, 3 if I go over the page, were matters of Miss Thompson-Beelman was also aware. Now, the particular questions you'll see, it starts with, is it alleged that Mr. Seiler knew any facts and matters in July 2010 material to an awareness of the alleged relevant risks which were not known to Miss Thompson-Beelman? Now, the authority did not know what Miss Thompson-Beelman knew. It could not answer that question other than the way that I've done. But equally well, and in my respectful submission as a perfectly fair answer to the question, no, the authority had no positive case in that regard. We were certainly not going to take points on the basis that Miss Thompson-Beelman didn't know something. And you'll see then at paragraphs 2 and 3, questions specifically asked about Miss Thompson-Beelman. 3, is it alleged that a reasonable person in the position of Miss Thompson-Beelman would have been aware of the alleged relevant risks? Well, to answer that, you need to have investigated what Miss Thompson-Beelman knew, what red flags she was aware of in totality, not just a subset of those Mr. Seiler's alleged to be aware of. And 4, if not, what distinction does the authority draw between the position of Mr. Seiler in July 2010 and that of Miss Thompson-Beelman? Now, it's important to understand who Miss Thompson-Beelman is. She was not approved at any stage within the UK regulatory regime. She never worked in the UK. She wasn't investigated by the authority. And the authority was not, on the basis of the case it had run, Mr. Seiler knew this, we say he had subjective awareness of risks, in a position to answer these questions unless it now went out and took an investigation of Ms. Thompson-Beelman and formed a view as to whether she didn't know as much as Mr. Seiler, or she had also acted without integrity, or whether she had been naive, or whatever. Those simply were not matters the authority could legitimately take a position on as they were not part of their case and not things that have been investigated.
Well, it might have been more helpful to say that.
Well, my lord, I understand that point, but in my respectful submission, the
I mean,
response...
this is as stony a stone wall as could be imagined.
My lord, I understand the question of tone. I do understand that, my lord. But in my respectful submission, the key information provided in the response is fair and correct.
But it's not a question of tone, Mr. George, is it? You say it's not a proper request for clarification of their case.
My lord, yes.
That's not tone.
It's a substantive point. And in a sense, with respect to my lord, it is the substantive point I make today.
Well, that's-
It is not our case as to what Ms. Thompson-Beelman knew or didn't know. It is not our case as to whether she was subjectively aware of matters or lacked integrity. This is not a proper request to clarify our case, because what you're asking for, and you're saying we'd like this as clarification, is actually not part of our case at all. And that's what that sentence means, in my respectful submission. And in a sense, that's the point I make to my lord. If we had put forward a pleading that said, Ms. Thompson-Beelman, that also, had put forward a positive case as to Ms. Thompson-Beelman's knowledge, I accept it would be perfectly legitimate to ask for clarification of that case and say, well, what are you saying that Ms. Thompson-Beelman knew? But we weren't. And if you look, my lord, and that's why this first sentence says what it says, I mean, the question, the clarification asked, Mr. Seiler approved of Julius Baer entering into final arrangement with Mr. Merenson. Mr. Seiler was aware of the relevant risks. That is not a sentence that is clarified by the questions that are being asked about somebody else's knowledge entirely. So in my respectful submission, it's not a proper request.
Well, is that right? Because you're also said to have pleaded that a reasonable person in Mr. Seiler's position would have been aware of the risks. So the question is, well, Miss Thompson-Beelman might have been a reasonable person. What do you say? She knew all these things and didn't do anything?
Well, my lord, let me deal with that in two respects. I mean, firstly, in my respectful submission, one can ask that, let's say one can ask that question, and therefore one could have said, actually, you're entitled to ask that question and to ask for the clarification. But the clarification you're entitled to in a case like this is that we set out at the second paragraph. So it's not like we stonewalled and stopped at the first paragraph. We go on to the second paragraph, which effectively answers the question. The authority makes no positive case in relation to the knowledge of Ms. Thompson-Beelman or the comparative knowledge of Ms. Thompson-Beelman and Mr. Seiler. The authority's case against Mr. Seiler is as set out in the authority's statement of case. And in a sense, my lord has identified the nub of the issue. Because if we are required to say, Mr. Seiler, our case is you knew 30 red flags, and this is our case on your integrity. If somebody is required, if the authority is required to answer questions such as, well, here's somebody who knew 2 of them, what do you say about her? Did she lack integrity or not? Either we are required to investigate that when it is no part of our case and no part of something with somebody we are legitimately entitled to investigate. One might say she doesn't work in the UK. She's not somebody we've chosen to investigate. It is, as a matter of practicality, very difficult for the FCA to fulfil its statutory function.
But isn't there a further, well, is there potentially a further point, which is that the assertion that a reasonable person in Mr. Seiler's position would have been aware of the relevant risks is something to be judged objectively, and it's not elucidated by asking what somebody else knew.
My lady, yes, in our respect submission, we absolutely endorse that point, without resiling from my acceptance that it's appropriate, if somebody asks for clarification, to make 100% clear, no, we do not rely on Ms. Thompson-Beelman, no, we do not draw that analogy, because that's a legitimate question. Are you making that positive case? To which the answer is no, we are not. And I appreciate the points you've made about the answer, but that is what we say in terms of my respectful submission. And if one goes on within this, because you'll see question 2 is pretty much the same, paragraph 10.3, same formulation. We have some more red flags that Ms. Thompson-Beelman is now said to have become aware of. same questions in relation to subparagraphs 1 to 4. And going on to question 3, you'll see this now brings in a Mr. Baumgartner. Now, Mr. Baumgartner, as you may have noted, is not one of the 4 relevant witnesses who is said, with accepting entirely my lord's point, but is relevant to the non-calling of witnesses point. It's somebody completely different. He knew some red flags, different red flags, that said to Ms. Thompson-Beelman, what do you say about him? Question 4, we have here a Mr. Nikolov and Mr. Weidemann. And Mr. Weidemann doesn't even appear in the extended list of witnesses which my learned friend relies on in her skeleton argument. He goes beyond even that. We have a 6th person at question 6. This is a Mr. Courier. You will see that at the end of question 6 on page 9. The same type of question, but now looking at a Mr. Courier. Question 7 is different. It's a standard request and is answered. I don't think any criticism was made of that. That's not relevant to today's purposes. And then question 8, you'll see it's now done on a compendious basis. So at question 8a, we're on page 10. We have another red flag, a list of people who may or may not have been aware of those red flags. You'll see on line 3 under subparagraph A, Mr. Nikolov, Miss Bone, and that's a 6th person. Miss Bone enters the picture here. Mr. Baumgartner, Miss Thompson-Beelman, and Mr. Weidemann. And the question in 8.1, is it alleged that Mr. Seiler knew of any facts and matters in August 2010 relevant to the alleged risk that Mr. Merenson's request was an attempt to disguise the true nature of the payment, which were not known separately to each of these individuals? So that's all 6 of them, and you'll see the same formulation at subparagraph 2 and subparagraph 4. Then on question 10, you'll see at 10a, having had these 6 individuals, we now have a compendious description at line 2, down at the bottom of page 12, of considered by the BJB legal department. And then on going over to page 13, in subparagraph 1, is it alleged that Mr. Seiler knew of facts and matters relevant to the alleged risk aforementioned which were not known to Ms. Thompson-Beelman and or Mr. Baumgartner and or the BJB legal department, and as explained, the same formulation then used in respect of this corporate entity, which obviously may contain different individuals of whom the authority was entirely unaware. So we have a very long series of questions which require 6 individuals and a legal department to be investigated in order that a position can be taken as to what they knew objectively and whether subjectively they were aware of relevant risks and what differences we relied on as between them and Mr. Seiler. They come in at different points of the story. They know different red flags to Mr. Seiler, but they're said to know some of the red flags that Mr. Seiler knew. What we are asked is our position in relation to all this. And in my respectful submission, our answer is a proper and fair one, that I accept the point about proper request, but it is not a request for clarification that we are required to answer beyond making clear, as we do in the second paragraph of each of these requests, we do not have a positive case in relation to these people. If we did, we would have to tell you and we'd have to call them. But that's not what this is about. This is about the fact that even though the tribunal has held it was reasonable for us to bring a case against Mr. Seiler on the basis of what he knew objectively and what we say that must have made him subjectively aware of, we have been unreasonable not to provide a positive answer to these factual requests for information, for clarification, in circumstances where we had no positive case to make, didn't made that clear in the answer, and couldn't answer the questions.
Was it in fact your case that a reasonable person in Mr. Seiler's position would have been aware? So I think you were accepting, as I've understood it, that you had to prove that Mr. Seiler was aware.
My lord, is entirely correct to raise that. It did come up. It was part of an alternative case, and without developing it too much, there had been some tribunal authorities in which, certainly in my respectful submission, there had been some conflict between whether recklessness was an entirely subjective test or whether there might be an objective element. And we pleaded an alternative case. So it is right to say that was there. It is right to say that was there. That alternative case was rejected as a matter of law, and nobody has sought to challenge that. So I accept entirely the subjective test is what this case was determined on.
Because that's the peg on which these questions are being
Precisely.
asked.
They are. But I accept there was an alternative case there, and I have to accept that.
And I think your Mr. Neary at the substantive hearing accepted, because this is recited in the cost decision, that it would have been, that it was relevant as to how other people would have reacted at the time.
Well, that is obviously evidence Mr. Neary is entitled to give, and objectively he may be right or he may be wrong about that as a matter of principle. But in my respectful submission, even if one accepts that it might be relevant in the way, in the sense in which I say the tribunal have looked at this, which is we want every, and I know there's a danger of putting it too high, but in the inquisitorial sense of we want all of this information. The fact, whether Mr. Neary was right or wrong about that, I, in a sense, in my submission, cannot change the objective legal position I advance today. Either I am right or I am wrong when I say it is reasonable for the FCA to be able to bring a case based on somebody's knowledge and their subjective awareness without being required to investigate and therefore answer information in relation to all of these people. In my submission, the comment, the observation by Mr. Neary, does not detract, if I'm right in the underlying proposition, from the fact that it's a case that we're entitled to bring, and indeed have been held that it was reasonable to bring. My Lord, so in our respectful submission, we were entitled, you've had submissions on what unreasonable means, but we were entitled, actually it was entirely reasonable, it was right to answer this question in the way we did. And we couldn't do anything else, we couldn't make it up. I mean, we didn't know what the answer was and we wished to bring a case without doing that. One looks at what the decision was on this, and it's at page 101 of the core bundle. And it's at paragraph 129. As regards the authority's failure to engage with Mr. Seiler's request for clarification about the knowledge of others within Julius Baer and details of the investigation, I find the authority's response to these requests to be unreasonable, so that's the finding, the jurisdictional finding. I accept Mr. Seiler's submissions that the tribunal would have been assisted had the authority given a more positive response, because as Mr. Neary accepted his evidence, it is relevant to look at how other people reacted at the time. And I make two submissions in relation to that. Firstly, it is clear when they say engage with more positive response, this isn't a question of tone, that's not the finding here. They are saying we should have told them what other people were thinking. They do, as my Lord has identified, highlight the fact that a member of the FCA's staff accepted a proposition put to him by one of my learned friends, that it is relevant to look at how other people reacted at the time. But in my submission, that cannot elevate this point. It's either right or it's wrong when I say we were entitled to bring a case without investigating and without making assertions and without relying upon assertions, that we would have had to investigate if we were going to make them, about what other people who we didn't investigate, who we didn't regulate, thought or knew on the basis of the fact that they knew some of what Mr. Seiler knew. And then the only other passage here is at 150, which is on page 103. I consider, informed by the background of the authority's failings in its investigation, that the failure to engage with Mr. Seiler regarding the request for clarification of details of the investigation were serious matters. I'll deal with the request for details of the investigation momentarily, but that's all that's said, it's serious. So that's all the reasoning in the tribunal's decision, and then I have shown my lords at page 109 in the refusal of permission. That's the reason, line 4, I emphasise the point at paragraph 16 that the tribunal has a supervisory jurisdiction in relation to references of this kind, which makes the position different to normal civil litigation. And that's the point I addressed you on earlier in terms of, well, is that really a proper analysis and correct legal analysis? And then it goes on to say, in those circumstances, it was clearly open to the tribunal to conclude that the authority had acted unreasonably in not responding in a cooperative manner to Mr. Seiler's requests, notwithstanding the fact that matters concerned had not been considered by the authority in preparing its case, most likely due to the deficiencies in its own investigation. Well, that brings into question what in my submission is the nub. Are we entitled to bring a case on the basis of the knowledge, what Mr. Seiler knew, what he was aware of? Or are we, in order to act reasonably, which it must be supposed we are required to do when it's been drawn to our attention, required to provide this information in relation to matters we haven't investigated and don't rely on? And in my submission, my Lord will see why this matters in other cases if we are required to investigate the knowledge of everybody who might be said to know some of it.
There are two slightly different points, aren't there? There's a pleading point
My Lord, yes.
and there's an investigation point.
My Lord, yes.
And what the tribunal seems to be focusing on here is the pleading point.
Well, my Lord, what they are saying, and obviously their jurisdiction only goes to what happens within the proceedings, but what they are saying is that we should have provided more information.
Yes, I mean, you might have said about Miss Beeman Thompson Beelman, she's not regulated by us, we haven't investigated her, we have no idea what she did or didn't know, but it's not part of our case.
Yeah.
Instead of just giving two fingers to the...
Well, my Lord, I understand the point, and I won't keep addressing it, but in my respectful submission, the point, the principled parts of that message, if I can put it that way, were conveyed in our response, that this is simply not part of our case.
Well,
and
yes
we
and no,
don't.
but it might have been helpful to Mr. Seiler to know that you hadn't investigated. You hadn't investigated her at all. So you had no idea what she did or didn't know, because he might have done.
Well, you see, this is one of the... they knew who we investigated. That is set out in notice of investigations and obviously part of disclosure. And as we'll come on to, I mean, the tribunal have not accepted the submission that, well, why should we call them? They can call them if they want. I mean, it's not a question of they didn't know. That was known. We had been held, it doesn't matter. You'll have seen it in the main judgment. It's the authority that has this duty. I mean, you're right. Nothing could have stopped the other side from contacting Ms. Thompson Beelman, and as we'll come on to, they may well face the same problem we had, which is you didn't want to be involved, but I'll come on to that. But my Lord, in my respectful submission, what the tribunal have decided, by the looks of the three passages, is that we are required to advance a case as to the knowledge of these. It may not be all, I accept that, maybe if we're given five, they'd have learned off one, but we have to advance a case as to the knowledge of people we have not investigated.
Well, Mr. George, rather what they seem to have decided, and do correct me if I've misunderstood, is they decided with their much more detailed knowledge of all of the facts of the case, that your response in respect of those requests for clarification was unreasonable.
Precisely, my Lord. I'm willing to, I accept that as a proposition.
And
why?
Well,
Go on,
no,
of course.
and on our exercise of the appellate function, it's not a question of whether we would wish to substitute our value judgment for theirs. It's that that's wrong in law for the tribunal to have
Precisely.
done that.
And there are two submissions I make on that, and I won't repeat them, but the first being, as I have shown you in the tribunal's reasoning of and refusing permission to appeal in particular, the point they emphasise in reaching that decision is their conclusion and their analogy, the difference between these proceedings and civil litigation proceedings. That is clearly a highly relevant consideration to the tribunal because it is, in my respectful submission, the only one they adumbrate. If they have taken into account an irrelevant consideration, that in itself is a legal error for the purposes of this function, of this judicial appellate function. But the way I put the case, as I hope I have set out, is more in the case, it's not so much it's irrelevant, but it is wrong to reach those conclusions, to take that into account. We've looked at what they mean when they say the differences, because that was set out in the main judgment. And so that is wrong. So when they reach a finding it is unreasonable, if I am right, they are doing it on the basis of that belief and decision as to the tribunal's function and the difference between the tribunal's function and normal civil litigation. And if they are right about that, if they are right about that as a matter of principle, I can see it is much more difficult for me to say that, well, this is unreasonable because you have this inquisitorial function and that's what the tribunal's entitled to expect. If I am correct that what they say about the difference between civil proceedings and these tribunal functions is flawed and wrong, and they have taken into account, as they clearly have, because they tell us that, then that is a legal error. Now, obviously, this tribunal is entitled to do a number of things. If there is such a legal error, it can decide for itself it wouldn't have made any difference. It can decide for itself it would have reached a different result. It could theoretically remit it. But in terms of why do I say that it's not simply a case of, oh, well, this RFI is either answered, or it's just a finding of reasonableness, it is because it is based on that principled, I say, error of principle, error of law, as to the relation, as the nature of these tribunals' findings. But, my lord, if I'm wrong about that, as I say, there is a second limb to this appeal, which is an irrationality proposition. And I put that on the basis, and I hear what my learned friend, my lord, has said in relation to these requests and the response. But in my respectful submission, we have answered the substance of the case that we were asked insofar as it was legitimate, in that we have been asked, effectively, is it alleged? Do you say X or do you say Y in respect of 6 individuals in a legal department? And we have said in terms, no, we don't. That is not our positive case. We make no positive case. And that fulfills the function, if you like, the legitimate function of the request for clarification in making sure we are kept within our parameters, and we have asserted and made it clear that we make no positive case in relation to that. It is unreasonable in an irrationality sense to say that we can, that that's not permissible in circumstances where they've held that it was reasonable to bring the case in the first place. And I also submit, and finally in this regard, my lord, it's unreasonable because the court and the tribunal, whether in civil litigation or in this proceedings, has power under its rules, is expressly empowered to order the provision of further information on the application of a party before it. And I do say, and I appreciate this just goes to the irrationality ground, it's not doesn't really relate to the point of principle, but it is irrational for a tribunal to make a finding that high hurdle of unreasonableness on the basis that a way that an RFI or request for clarification has been answered, where the party who received it did not seek to make an application that it be answered more fully. At the time, this was asked and this was answered, and as I say, we made clear our position. We have no positive case on these matters. We are held to have been unreasonable in circumstances where there was no application on the basis that it could have been made. Well, inquisitorial function, you've got to provide them a positive response. The parties proceed on this basis, and then we are told at the end that actually this was unreasonable. So in my submission, it is irrational to effectively go back to this interlocutory request when it wasn't, when the rules that allow for these matters to be brought before the tribunal were not done at this stage. Now, my lord, the second of the matters relied on, you'll have seen request, was a request, it wasn't even a request for clarification, it was a request for disclosure in correspondence, and that's also taken into account. So my lord, maybe look briefly at that. In the judgment, and you'll see this is at page 101 of the core bundle. They've shown that, but my lord will see paragraphs 129 and 150. These are the only references to the same provisions as we've just seen for the request for clarification. Yeah. So this is inter partes correspondence. There are 3 letters referred to, and they start at supplementary bundle tab 2, page 18. So there are provisions about disclosure, directions that don't concern us. What this court is concerned with is on page 19 and the paragraph beginning 3rd.
I'm afraid I've lost where we are.
I do apologise. Supplementary bundle, tab 2,
Tab 2.
page 18, and it's the first of the 3 letters in relation to disclosure. So, my Lord, you'll see. Third, it may be that provision is needed for disclosure in order to assist in determining whether it may be necessary for us to make an application for disclosure. Please could you in the first instance provide us with details of the various information requirements, documents, requests made by the FCA investigation team. That is responded to at page 20. And the relevant part is the last paragraph. In respect of your request to provide details of the various FCA information requirements, we say the request is disproportionate, and we set out why and why it doesn't fall within the disclosure rules. There is then a further correspondence at S420.
Sorry, just before we go on, could you just remind me for whom were Mishcon de Rea?
Mr. Seiler.
Mr. Seiler.
Yes, I understand my learned friend Ms. Clark, who appears for Mrs. Whitestone, does not take a position in relation to
Yeah, no,
ground 2. These are just a Mr. Seiler point. So they're written on his behalf. He thinks he wants to may want to make an application for disclosure. He asked for this disclosure. We say it's disproportionate. It then goes to tab 4, page 21. The relevant part is page 22. And you're looking at the second paragraph. And it's fair to say this really is the parties repeating their positions at this stage. And they invite us to disclose again. And on page 24, we repeat our position. This is all in May 2022, leading up or just in the context of proposed directions and what should be disclosed, what shouldn't be disclosed. The type, in my respectful submission, of inter-parties correspondence that is relatively familiar. But what is then important, and I make no criticism of Mishcon de Rea in this letter at all, on the 9th of June 2022 at page 25, they say this: we disagree with much of the FCA's email. In response, however, rather than debate points in the abstract, in order to be constructive, we focus on one particular aspect of our client's case. That is a point of particular concern as in respect of documents relevant to our client's position, that much of his time spent at Julius Baer during the relevant period was spent working on other matters, i.e. matters outside of those which form the subject matter of these proceedings, rather than on the matters with which these proceedings are concerned. Our client does not have access to his emails at Julius Baer from the relevant period, and on the basis of the documents that have been disclosed, it is unclear whether disclosure searches undertaken by the FCA would have captured anything in our client's emails during the relevant period in relation to our client's engagement in such other matters. So the point he's making is, well, we want to find out effectively how busy we were on other matters. And so the requests are reduced, as it were, to those you see at the top of page 26. The key point of subparagraph 1, were the information requirements such that they captured our client's emails, which contain material related to other matters in which he was involved. And we answer this at page 27. You'll see in the second paragraph, the information requirements document requests issued by the FCA were, in accordance with its statutory powers, properly focused on the matters under investigation. We do not propose to review the information requirements or responses thereto to verify whether there are any emails involving Mr. Seiler which incidentally contain reference to other matters in which your client may have been involved. So we provide information, and important information, that no, we didn't target information requests in relation to other matters. And of course, incidentally, things may have been picked up, but that's all we did. And at the top of that page 27, my lords, you will see the answer, the second paragraph, and I appreciate they say they don't think it was particularly helpful. But you will look at the paragraph 3 lines from the end. They say this is unhelpful. However, given that your response makes clear that the FCA does not have access to our client's entire mailbox from the relevant period, we do not propose now to continue this line of correspondence. So, in my respectful submission, this is typical of inter partes and proper inter partes correspondence in the run-up to a directions hearing about disclosure. There is a wide request, it said it's disproportionate. There's a focused request, it's partially answered, and the response comes back, well, we now know what we really needed to know, which is, do you have anything useful? You don't, because you've made clear you don't have our client's email address, and the only information in relation to other matters will be incidental. No application for disclosure is made in this regard, and as you'll have seen from Mishcon Derea, they didn't continue the correspondence. Now, I appreciate I don't have a point of principle here, I accept that, but I do rely on the second limb, the rationality grounds, and in respect of the high hurdle for unreasonableness, that it cannot be right for us to have been unreasonable in respect of this exchange of correspondence, which ends with us having provided the information that leads to the other side not making any more application, because we've told them the kernel, in my respectful submission, of what they wanted to know for their purposes.
And are we now going to go to the part of the cost decision where this specific exchange is dealt with?
Well, Lord, yes. I mean, that's
Well, that would be helpful, I think.
that's the summary of my learned friend's case in relation to it. I apologise if I'm missing the passage, my lord.
Well, it's the part of the submission as to why that was unreasonable.
It's like the grounds for the application, a paragraph.
Well, I'm looking at 116.3.
I'm very grateful, my lord. Precisely, that Mr. Seiler submitted that there were specific aspects of the authority's conduct, and then in the indented passages it sets out verbatim, as far as I'm aware, from what Mr. Seiler said. So that is the case advanced to the tribunal. It's not, in my respectful submission, one that's then dealt with by the tribunal beyond what you have seen at 129 and 150.
Could you show me, Mr. George, where in your grounds of appeal or your skeleton argument is it said that the tribunal's decision was irrational?
Well, no, well, may I take it to the skeleton argument first, and then I'll, because it's paragraph 52.
Looking at 55 and 56, you say it was wrong. You say there's a principle, that's your civil litigation analogy, but you say that if you're wrong about that, then the decision was irrational, but I can't see that that is either in your ground of appeal 3 on page 17 or in your skeleton argument. Bearing in mind that Mr. Seiler isn't here.
I know, my lord, I accept that entirely. Well, we set out at paragraph 3 the bases upon which we challenge these decisions.
Paragraph 3 of the skeleton.
Precisely. We say are wrong in law.
Yes.
Additionally contingent on a false present, and they say, and then we, in terms of unreasonableness and we set out at paragraph 52.5 our submissions in relation to unreasonableness, which we set forth in relation
That's ground 1.
to a number of the different witnesses.
Yeah, that's ground 1. We're dealing with Mr. Seiler, aren't we?
Well, I accept the point that is being made, and I put it on this basis that in order to show that it was unreasonable, as I have shown from the RFI, I am obviously needs to rely and do rely on the fact that it was wrong to take into account this the difference between the nature of civil proceedings and if I'm wrong about that, it can't be, it's not irrational. So to that extent, they are linked. My lord is right.
Yes.
So I entirely accept that.
And you do make the point, I mean, it's obvious in paragraph 3 of the skeleton, it used the correctness of the findings, which is wrong in law. Additionally, alternatively, in each case, contingent on a false premise as to the property.
Yes, my lady, exactly, my lady. But I think I accept the point in a sense. I can pray in aid, and I do pray in aid, that it is a factor to take into account that these weren't the subject of a formal application for request for information. They weren't the subject of a formal application for disclosure. But I accept that what I'm saying, if I'm wrong about the nature of the tribunal's proceedings, if they are this inquisitorial, if they are analogous to judicial review, it's not irrational once that's your starting point. I accept that. Yeah. So, my lord, may I move on to the issues about the witnesses, which is ground 1. And there are 4 different witnesses who are relied on. There are some more that come within my learned friend's skeleton argument, and Ms. Rooney will very briefly deal with those in due course. But let me focus on the 4 main ones, having made my submissions in relation to the points of principle. And at paragraph 119 of the costs decision, from my lord sees at page 99, you'll see the conclusion in respect of Mr. Cambiano. I accept that the fact that the authority was of the view that Mr. Cambiano could not be tendered as a witness of truth created some difficulty, and then there's an acceptance, further acceptance of a submission we'd made. And so number 3 answer, in the circumstances, the authority should have sought directions from the tribunal as to whether Mr. Cambiano should be called as a witness, and if so, how that should be managed. So we're dealing here with an individual who we did not regard as a witness of truth, who we did not rely on, and who we did not seek to tender any evidence from before the tribunal.
But you were influenced by his account.
That's what the finding is made in terms of our thinking in bringing the case. I can't go behind that, maybe not, but that's not relevant to the case before the tribunal, which was the pleaded case which the authority brought, the evidence on which it relied, and the correctness of the case which it pleaded. So the fact that at some point, and obviously in a sense, Mr. Cambiano, as a matter of causation, clearly, without wishing to be over colloquial, kicked the whole thing off in that he was the one who first brought these matters to light with an email. But he wasn't part of the evidence or the case which we brought. And indeed, because we did not accept what he said. I mean, we did not think it was a witness of truth. He was not somebody on which we could rely, not somebody upon which we could invite the tribunal to rely. And it is said we should have sought directions from the tribunal as to whether Mr. Cambiano should be called, and if so, how that should be managed. And I have shown you in the refusal of permission of appeal that the justification for this is again said to be the differences between civil litigation and these tribunal proceedings, which I have addressed you on at an earlier stage. And in my submission, I won't repeat them all, but in a sense, this is the paradigm example of how wide-ranging those findings are, that legal analysis is, if truly, because of the duty of candour, the FCA, section 133 of FISMA, we are required to take directions effectively to call these people. And in my submission, that is a very different jurisdiction to the one that exists in civil litigation, which we say is the true analysis of these matters. So that's Mr. Cambiano, and you will have seen how it was dealt with in the original decision in respect of Mr. Cambiano. The tribunal, in its original main decision, said that we should have called Mr. Cambiano and sought to treat him as hostile. That's at page 420 of the authorities bundle, paragraph 112.
Yes. Miss Clark doesn't support that.
I apologise. No, Miss Clark doesn't adopt that, and the tribunal, as I have shown in the cost decision, has somewhat resolved from it. It's worth just seeing it so that you'll clear it is there. So originally, it was said 4 lines from the end of para 112. It could have applied to the tribunal permission to treat Mr. Cambiano as a hostile witness, with the result that all parties could have cross-examined him. And as you say, neither my opponent nor the tribunal in the cost decision are adopting that. What they are saying is directions should have been sought.
Yes.
We make the point in the skeleton that doesn't, in a sense, in our Aristotle, answer the point. I mean, directions for what? Because calling him as hostile is not something we could do on the authorities, and it's not something we say on the correct analysis of the nature of tribunal proceedings. Certainly we should be required to do in circumstances where no one is tendering him as a witness of truth. So, my lord, in my respectful submission, and again, there are 2 limbs. As a point of principle, it is wrong, and the tribunal are wrong in the analysis which I have shown you, to say that we should have taken further steps, whether that be sort of airing it at directions hearing or tendering them and trying to treat them as hostile. But to turn the point around, we say we are entitled to, because they've got the point of principle wrong, treat Mr. Cambiano as you would in any other civil litigation, as a witness who we don't believe and we don't rely on and we don't need to rely on if we're right in our case. He's not part of the case we are bringing, and that should be that.
Yes, I mean, in the main decision, the tribunal also criticised the failure to investigate Mr. Campiano, and they said that was...
They did.
I'm not sure they said it was irrational, but
They came close.
it must be questioned on rationality.
Precisely. They didn't like that decision at all. But that's not part of their cost decision and couldn't be, and they accept that. I mean, they know that. That's nothing to do with how we did the proceedings. Whether we should have investigated someone else is, I mean, there are political investigations, it regularly comes up, but it's not part of their function. So they felt that Mr. Cambiano, if he wasn't a witness of truth, yes, clearly should have been investigated and proceedings brought against him. But that doesn't go to the question, in fact, if anything, supports my point as to why we didn't call him and why it's wrong for us to have been held to be unreasonable in not taking further steps for a witness who we weren't calling, weren't relying on. And I think my lord made a point earlier. I mean, anyone could have if they wished to sort to call them themselves. As I said, that submission fell very flat with the tribunal, but it is in my submission simply obvious as a matter of logic. You exchange the witness statements of those witnesses on whom you wish to rely. If anyone had said, oh, actually, we'd like to call Mr. Campiani, now we see you haven't, they could have done so. Nobody wanted to call him. Nobody said he was a witness of truth, and you'll pick that up from the main judgment. So we say this is wrong in law on that basis, but to go back to my alternative case, and happily I do have this in the skeleton argument of paragraph 52.5 expressly in relation to Mr. Campiani, it cannot really meet that high test of unreasonableness that we didn't appreciate we should do this for Mr. Cambiano in circumstances where it had never previously been suggested that we had to take such steps in requests of witnesses who we didn't rely on and we didn't consider to be witnesses of truth. Now, my lord, we get to the more high-tempered, if I can put it that way, part, which is Mr. Thompson-Beelman and Mr. Courier, where I do say that the observations of the tribunal are not justifiable. I have said this in my skeleton, because they are constructions of correspondence which do not bear the construction which the tribunal have put on them. They're correspondence that the tribunal hadn't seen before the costs hearing, so there's no question of it being witness evidence. This court is in as good a position to look at them as that. But let's have a look. It's Miss Thompson-Beelman and Mr. Courier, and in the main judgment, what is said, it's at page 418, paragraph 97.
This is a tough point for you to dress up as a point of law, isn't it, Mr. George?
Well, in my respectful submission, if I'm right on the point of principle about the nature of these proceedings,
Well, then it doesn't add anything.
well, my lord, the point I'm seeking to anticipate, and my lord may say, no, is even if you're right on the point of principle, there must be some witnesses you just should have called. It's that point that actually, even if you're right on the point of principle, and it's not quite, I still think you should have called Miss Thompson-Beelman, for example. So that's why I address you on what we did. And I'll do so briefly, if I may. But paragraph 97, you'll see it says, of course, there may be a satisfactory explanation for the absence of particular potential witnesses. There may have been practical difficulties in obtaining evidence from Ms. Thompson-Beelman and Mr. Courier, who we understand to be resident in Switzerland, but we had no explanation from the authority as to whether they did at any stage consider seeking assistance from these potential witnesses in any respect. So at this stage, the tribunal seemed to be proceeding on the basis that the fact that they were abroad might have created a legitimate reason. And it's in the basis of that for the purpose of the cost decision, the relevant correspondence, which was obviously privileged, was disclosed. And my lord already made the point the tribunal did not find that satisfactory, but I will make the submission when we go to look at the cost decision. That's not part of their reasoning here. That's not why we were found to be unreasonable for the purposes of their costs award. What they found to be unreasonable was when they looked at the correspondence, they found it to be unreasonable in its terms. My lord will look at
Yes,
that. in the
well,
cost decision.
they took the view that it was encouraging the witnesses to refuse to
They did.
cooperate.
They did, and that's why I say I have to. No, I can't accept that finding. I could accept a lot of what the tribunal say. I can't accept that for the purposes of this appeal. It's a matter of construction. It's a letter. There's no evidence was given on it. As I say, they hadn't seen it before. So I do invite this court to have a look at it. And what we have it is at tab 13, page 37 of the supplementary bundle. Now, my lords have read deeply into this case. I wasn't proceeding to read this out, but my lord, because of the nature of the criticism made, I do invite, if the panel was willing, just to read the letter, starting with strictly private and confidential, in its entirety, because it has been regarded as so unacceptable. It's sent to Miss Thompson-Beelman. Mr. Courier gets an identical one for him.
And less defender, right? That you're on 30 point.
No, 37. It's the one I'll go back to the letter.
Yes.
And then the similarly one for Mr. Courier, which I don't think this panel needs to read because it is pretty identical, as at tab 15, page 46.
Yeah.
And then one sees a costs decision at paragraph 1, 2, 3. The correspondence demonstrates that the efforts the authority took to obtain the assistance of Ms. Thompson-Beelman and Mr. Courier, initially through FINMA, and I'll come to that letter to FINMA in a moment, were utterly feeble. Third sentence, it was quite clear from the tone of the correspondence that the authority was in effect encouraging a negative answer to its request, and that it was in effect only going through the motions to give the pretense that it was serious about obtaining the assistance of these individuals. So that is the finding that is made on the basis of the correspondence between the FCA and Ms. Thompson-Beelman, which you have just looked at. And I make the submission to my lords that that is not a fair or permissible finding to make, and there's nothing more than the construction of these letters, on the basis of what was said. It is pretty standard form for the FCA, and obviously if that's the view that's taken of it, so be it. But there is nothing in that letter that is encouraging a negative answer. It's asking if she'd be prepared to give evidence, and each of the letters does. That finding is unsupportable in my respectful submission. But obviously what I now need to show you is the letter that's relied upon, that's quoted from, which is the letter to Finema, which precedes the letters.
Just before you do that, in the cost decision, there's also two other criticisms, aren't there, in respect of these witnesses? The first of the other criticisms is in 122.
My lord, yes, which you, my lord, has exactly set out.
And what do you have to say about that?
Well, my lord, I mean, I've made 2 points. Firstly, we say that, and I appreciate it's a finding, but we're bringing our case, it's going to, at trial, it will win or lose on the basis of the evidence which we have set forward. We are entitled, and this may simply go to the point of the nature of the tribunal proceedings versus the nature of civil proceedings, to, well, we are not required, in order to be reasonable, in my respectful submission, to advance an explanation or to provide information about who we have and have not called. We could do, and we can waive privilege in relation to that basis. But in our respectful submission, that is not something that is necessary. And secondly, in our respectful submission, we were entitled, for the purposes of the costs hearing, to disclose it, and indeed findings have gone on to be made in relation to that matter.
I don't think the criticism that they're making in 122 is you producing the letter for the costs.
Yeah, exactly.
I think it's rather that you were not frank, that you'd made an attempt to contact them already and the tribunal wasn't told. That seems to be...
My lord, that may well be right, and I accept that, in which case I make the submission that that is not a finding that is open to them unless they are right about the difference between the nature of civil proceedings and the tribunal proceedings. Because if it is an inquisitorial jurisdiction, I can quite see we should have told them. But in a civil, in what I say is the proper narrative of civil litigation, I don't say it's unheard of, but it would be extremely unusual to explain who you haven't called or why you haven't called them, or to get into that type of privileged material. We hadn't called them. We therefore weren't relying on them. We had no positive case in relation to them. That was our position. And if we're right about the analogy in our submission, that's right. I fully understand my lord's point as to whether that is a part of the actual decision. We see at 128, I therefore conclude the authority acted unreasonably in the conduct of the proceedings in relation to its approach to potential witnesses referred to above. I confess I had read approach as effectively the correspondence that had been sent to them, i.e. the approach we made to them. I think my lord is saying, no, the approach could be all of the things that have been referred to above.
All right. Even on your view of what approach means, at 127, there's also the observation that the gentle requests that were made came in possibly late. And that's also one of the criticisms in respect of the witnesses.
It is.
And what do you say about that?
With respect, it is simply an insupportable finding to make. And I appreciate the point of principle is because this is a separate question about late.
Some of the witnesses responded by saying it was too late. Potential witnesses, didn't they?
Oh, my lord, let me just set out the timetable so that my lord has it. The requests were made on the 8th of July 2022.
39, somebody called Jean-Marc Fellet says your request comes a bit late in the game.
No, I'm sorry, my lord, but that's because he'd already been approached by the other side, agreed to give witness for the evidence for the other side, and turned up at trial to give witness evidence for the other side. It was too late because he'd already been engaged, which is fine, because we had his evidence.
Well, all right, Ms. Beelman, you write her at the beginning of July, and the first of your temporal points at point 2 says we'd need you to travel to London by early September. That's not very much notice, is it?
Well, my lord, the facts are what the facts are. My lord will make a decision, but my submission is that the requests were made on the 8th of July. The timetable in this trial had been set a week earlier. So the directions order comes out on the 1st of July for witness statements to be exchanged on the 26th of September 2022. And I can't put the submission higher than this. That cannot be said to be impossibly late. It's a perfectly standard timetable for a piece of civil litigation. If Miss Thompson-Beelman had come over in early September, we'd have taken her witness statement. Many commercial court cases have 3.5 months for witness statements.
That's a rather different point, isn't it? You're saying to a witness overseas in July, we need you by early September, and the tribunal decide that that request is impossibly late. And you're saying, I think, that that's an impermissible conclusion.
My lord, yes, and I do say that.
Very good.
And obviously, my lord will decide, and I accept what my lord says. But you know, if it had been the next day or the next week, I would accept that. But
Right.
this was the timetable that was set. The director's order had only come out a week previously, and we had till the 26th of September. This is the sort of timescale in which litigation does, and in my respectful submission, should operate. But I can't put it higher than, you know, it doesn't really go to my point of principle. Simply to say it's impossibly late. But I play that in. But may I go back to the letter from FINMA at 123, because obviously the tribunal have criticised that. Now, you've seen what we wrote to Ms. Thompson-Beelman and what we wrote to Mr. Courier, and that we got their contact details by writing to the Swiss regulator, FINMA.
Yeah, and you appended a text of what you
And
actually
we appended the text of the letter. And my lord will see that at,
tab 11.
I'm very grateful, my lord, S11 30.04. And we asked for the contact details. I don't need to ask my lord to read it. We appended the text of the communication we intended to send to them. What the tribunal seemed to have construed as effectively meaning that the FCA were acting in this duplicitous, pretentious manner is paragraph 16, where it is said, we think it is quite likely that many, if not all, of the individuals will decide not to participate in the UK proceedings, but it's important for the FCA to demonstrate to the Upper Tribunal that we tried to obtain all relevant evidence for the Tribunal's consideration. And again, my lord is looking at the correspondence. There is only so much that I can do in submission that can, because my lords can just see it for themselves. But in my respectful submission, that was an entirely fair presentation of the position to the Swiss regulator. It obviously isn't part of the text that is to be sent or eventually is sent to the witnesses themselves, but it is, and my lord will have seen this from paragraph 126 of the tribunal's costs decision at page 101, the reality of a position which the tribunal accept. Sees that at page 101. It is no good for the authority simply to wring its hands and say there is nothing we can do to secure the attendance of a witness, who, if he or she is asked only on the basis up to him or her whether they wish to assist or not, will inevitably politely decline to assist, as happened in this case. And that may be right, as was said in the letter to FINMA.
If you're right on your point of principle, this is just ordinary civil litigation, and you can advance the case on what evidence you please, why do you say to FINMA that it's important for the FCA to demonstrate to the Upper Tribunal that we tried to obtain all relevant evidence for the Tribunal's consideration? Why can't you just say, well, we choose not to call this evidence?
Well, because of why we're here, my lord. It is clear the Tribunal have taken a view.
That's long before anybody got cost decision from the Tribunal.
No, but already we had seen the... I took my lord through Frensham earlier, and you'll have seen reference to Forsyth, and it's all the same judge. So and we knew we had Judge Harrington. That's no criticism of him, simply that, without waiving any privilege, it could be anticipated that some efforts would be of assistance towards witnesses, and doubtless that's why they are made, rather than taking the view not at all. obviously what happens is they are not prepared to assist, and that's where we are here today, because it's held that actually, even though that step was taken, that wasn't enough, because the point of principle that has been, you're right, if I'm right, I didn't need to do it. But the
Well, it was an odd thing to say to the Swiss regulator.
Well, I can see the point that maybe just be much more businesslike with the Swiss regulator and just say, please, we have the contact details. You don't need to be discursive, as it were. I can't, it is particularly with the tone of interregulator correspondence, but they're obviously trying to be relatively frank and encourage the Swiss regulator to give assistance. But it does not, and when it comes down to it, this is the finding we have in the costs decision. You've now looked at all of the material that's informed that finding. It was quite clear from the tone of the correspondence that the authority was in effect encouraging a negative answer to its request, and that it was in effect only going through the motions to give the pretence that it was serious about obtaining the assistance of these individuals. And you've seen not just the tone of the letter, you've seen how many were written to all of these witnesses, and we called those who responded, and you'll have seen the criticisms that the tribunal didn't find them terribly helpful. But in my submission, my lord, there is simply no basis, a matter of construction for that finding. Now, you're right, if I'm right about my point of principle, in a sense, none of this needed to happen, so in a sense, what is reasonable stops a long way short of this. But also, I can see the point being taken against me that if there was duplicity and pretence in correspondence or whatever, then that of itself would be unreasonable. But that simply is not in my submission a proper finding to be made. And I deal very, very briefly, if I may, with Mr. Narandes, because here is simply a straight point of principle. We say he's too peripheral, our decision. But I do want to show this panel what the tribunal found about him and why he was relevant. And that's at page 418 of the authorities bundle at paragraph 98 of the main bundle. Page 418, paragraph 98. And I do not and probably cannot go behind what the tribunal's assessment of his relevance is, but this is it. He had, line 2, he had some recollection of dealing with Mrs. Whitestone as regards issues arising out of the proposed arrangements with Mr. Merrison. Now, one might see on the inquisitorial analysis, on the judicial review analogy, if that's right, then the fact that he spoke with Mrs. Whitestone brings him within the penumbra of those we must call. But if they're wrong about that, and we are right that one is looking at a civil litigation style jurisdiction, this, I mean, with respect, there are lots of people who had dealings with Mrs. Whitestone, or indeed the other protagonists. It's a big bank and a big place. We brought our case on the evidence we brought it on and the witnesses we chose to rely on. And this, in a sense, encapsulates in our respectful submission the points of principle. There are, my lord, and we will intend to finish by lunchtime, my lord, but those are the matters referred to in the costs judgment, the witnesses, and those who were mentioned in written and oral submissions before the costs hearing. And my learned friend her skeleton has referred to a number of other witnesses who she said should have been called, which slightly makes the point of how important the point of principle is. But I'm going to ask, if I may, Ms. Rooney to address those very briefly, whilst making the overarching submission that as they were not even canvassed before the judge, they can't really form part of what I'm asked to defend.
Yes.
And I will just say something very briefly about change of case in conclusion.
Change of case.
Yes, my lord. I had addressed you earlier, but I just want to make sure I have addressed all the points taken against you in that regard.
Yes. Miss Rooney.
My lords, my lady, Mr. George has addressed you on the point of principle on this ground, and he's also addressed you on the issues as they were and as they were found by the tribunal below. In particular, the 4 effectively key allegedly missing witnesses, which is Mr. Campiano, Ms. Carolyn Thompson-Beelman, Mr. Curry, and then Mr. Narandes. Against that backdrop, we were somewhat taken aback to see in the skeleton argument filed on behalf of Mrs. Whitestone a whole raft of additional witnesses who were said to be missing, specifically 7. And if I can begin just by turning up my learned friend's skeleton argument, this is in the core bundle at tab 3, and specifically page 44. And then, sorry, flicking ahead to page 56, we're looking at paragraph 37 of the Whitestone skeleton argument.
Yes.
You can see what's said there. It says, there were in addition a number of other witnesses who featured heavily in the evidence and the authority's narrative, but who similarly were not called to give evidence. And what you then have in paragraph 37 is a list of 7 additional witnesses. And if I can just ask the court very briefly also to flick ahead to page 61. The first part of page 61 are effectively the sub-paragraphs of paragraph 44E of the skeleton argument. A lot of the same names appear, but in addition you have Mr. Felly. So what you effectively have are 8 additional witnesses in total to the 4 that Mr. George has addressed you on already. Now we do say at the outset, if my lords and my lady, you're without the authority on the point of principle advanced by Mr. George, you may not need to hear from the authority on this point at all. But otherwise, it is important to understand the issues as they actually stood before the tribunal at the cost hearing, and then to have the broad thrust of what the authority would say in respect of these additional witnesses. If I can address the first point there as to the scope of the issues that were actually before the tribunal. Counsel for Mrs. Whitestone at paragraph 37 of the skeleton has named 7 additional persons. To give you a flavour of who these people are, we have Mr. Daniel Gerber, who's the Chief Executive of JBI, Mr. Alan Dampier, the JBI Head of Compliance in 2010, Mr. Peter Nikolov, and this is effectively Mr. Wrightson, the third applicant before the tribunal, his right-hand man, Mr. Roman Baumgartner, the Head of BJB Compliance, Mr. Matthew Taylor, who was an investment dealer at JBI, and Ms. Melanie Denman. Some of the references in the skeleton are to Ms. Ferguson, the same person, but effectively Miss Whitestone's assistant. And then finally, Mr. Oliver Schwartz. He was the assistant market head to Mr. Seiler. As I say, there's an additional reference to Mr. Felly. He was someone who did appear before the tribunal, albeit called on behalf of Mr. Wrightson. To get the thrust of what is said in the skeleton, effectively what is said is that the authority failed to call these people, and in doing so the tribunal was hampered in its efforts to discharge its function under section 133 of FISMA. Effectively what is said is that the appellants were highly critical of these witnesses and that they should have been called, the absence of these witnesses, and that they should have been called. Now, respectfully, we do say that these 8 additional witnesses just do not form part of the tribunal's cost decision. Mr. Dampier, Mr. Nikolov, Mr. Taylor, Ms. Denman, or Ms. Ferguson, are not mentioned by the tribunal in its cost decision at all. There are references to Mr. Gerber, Mr. Baumgartner, and Ms. Schwartz, but they're only because there are quotations taken from the main judgment which effectively summarise the factual position as found by the tribunal. And there's no suggestion anywhere in the cost decision that the authority somehow failed to call these additional 8 persons now relied on by Mrs. Whitestone. And we say that frankly is unsurprising because neither Mrs. Whitestone nor Mr. Seiler actually relied on the absence of these additional witnesses in support of their cost application. If I can take you through the documents very briefly, starting with Mrs. Whitestone's cost application. That is in the supplemental bundle, tab 17, page 53.
Sorry, say that again?
Apologies, it's the supplemental bundle, tab 17.
Yeah.
And the application begins on 53.
I mean, the reference in Ms. Clark's skeleton argument to the additional witnesses might have been a ground for serving respondents notice saying, in addition to the missing witnesses whom the tribunal identified, there were these other missing witnesses too, but there is no such respondents notice.
Indeed, and I think even logically prior to that, had they wished to serve a respondent's notice before this court, they of course would have had to include it within their application for costs before the tribunal. They would have had to be saying one of the bases on which we say the authority has behaved unreasonably is in failing to call the 8 additional
Not
witnesses.
sure about that.
Perhaps if I take you through the documents, but I do agree that of course it could have formed a basis for a respondent's notice. If we start with Mrs. Whitestone's application, and specifically the part upon which costs were actually ordered, we're looking at the application on page 55 of the bundle, Rule 10(3)(d). This is about the authority's conduct of the proceedings. And you can see what's said there. It says, as regards Rule 10(3)(d), Mrs. Whitestone contends that the authority acted unreasonably in bringing, defending or conducting the tribunal proceedings. And specifically, there's a reference to the multiple failings of the authority in its investigation referred to above, which it did not remedy in the tribunal proceedings. Now, we assume referred to above is to paragraph 6, 7 and 8 of the same application. 8 addresses what is known as the third FX transaction, which is not before this court today. So really we're looking at 6 and 7. And paragraph 6 does not anywhere suggest that one of the bases on which the authority has been unreasonable and is in its failure to call witnesses. What you do have is a cross-reference to the main judgment, specifically paragraphs 107 to 149, and then paragraphs 920 to 930 of the main judgment. I can take you to the main judgment if it would assist, but in broad summary, paragraphs 107 to 114 address only Mr. Campiano. Paragraph 115 to 119 address the authority's position on or the delay, perceived delay by the authority. Paragraphs 120 to 137 address perceived disclosure failures. 138 to 140 address alleged failures on the part of the authority to gather relevant documents. There are some overall comments at 141 to 144, and then at 145 to 149 of the main judgment, we return to Mr. Campiano and specifically why the authority didn't progress an investigation in respect of him. And then you, in addition, have the comments at paragraphs 920 to 930 of the main judgment. And there is at paragraph 924 a reference to failure on the part of the authority to call key witnesses.
Could you just give me the reference immediately before the one that was 120, because I'm afraid I missed it. It was one of the first of the ones you gave.
Of course, so if we're looking at, is it the reference in the main judgment that you're looking
the
for?
paragraph judgment.
Absolutely, so it's the authority bundle, tab 18.
And paragraph reference.
Apologies, it's the relevant paragraphs cited in Mrs. Whitestone's are from paragraph 107 through to 149.
That's all I needed. Thank you very much.
And then, sorry,
And
just
the ones that came after that, you were grouping them into subsections.
absolutely,
Yes, I
and it's
understand.
just to clarify that in addition you have 920 paragraphs 920 to 930.
With
And
924 sitting in the middle of that. row.
absolutely, and we absolutely accept that in 924 there is a reference to the failure to call material witnesses. 924, however, refers back to paragraphs 93, and apologies for all the cross-references, 93 to 114 of the judgment, where the tribunal only dealt with 4 missing witnesses, and those are effectively the 4 that Mr. George has already addressed you on. So Mr. Curry, Ms. Beelman, Mr. Narandes, and then of course Mr. Campiano himself. So the short point that we say is that Mrs. Whitestone's cost application made no direct or even indirect reference to any of these additional witnesses being effectively a basis for unreasonableness. And indeed, the single paragraph 924 of the main judgment that does refer to it and that is incorporated by reference is only about the 4 key witnesses that we've looked at. The same is also true of Mr. Seiler's cost application. I don't propose to take you through it, but it's also in the supplementary bundle at tab 16. Instead, the missing witnesses point effectively in respect of missing witnesses at all, but in particular any additional missing witnesses, arose for the first time in Mr. Seiler's skeleton argument. That is in the bundle at tab 20. And again, picking up the costs application under 10, rule 10.3d, if I can take the tribunal to paragraph 30 of this skeleton argument. It's page 82 of the supplemental bundle. Now here, unlike the underlying costs applications themselves, in the skeleton argument we absolutely do have Mr. Seiler saying the authority failed to call material witnesses. But if you look at each of the sub-paragraphs under paragraph 30, what you have there are the same 4 key witnesses and not the additional 8 now enumerated in Mrs. Whitestone's skeleton argument.
Yeah.
There's no suggestion effectively it's part of a wider cast list. The same is true in respect of Mrs. Whitestone's skeleton argument. Just for your reference, it's at supplemental bundle tab 21, page 88. And the relevant passage is at paragraph 102.
Yes,
Is it page 102? Apologies.
yes, it's paragraphs 34 to 40.
Indeed. And Mrs. Whitestone is alleging a failure to call relevant witnesses. Perhaps more seriously also suggested cherry picking on the part of the authority, but no names are given except for Mr. Campiano at paragraph 38.
But again, she cross refers to the paragraphs of the decision that you've already shown us.
Indeed, and the most relevant and pertinent paragraphs of the main judgment are 93 to 114. As I say, that's really only the 4 key witnesses upon which Mr. George has addressed you. So we do say it just wasn't part of the costs application, and unsurprisingly doesn't form part of the cost decision in those circumstances. There is regrettably no transcript of the costs hearing below. I'm afraid there was a technical error with an echo that effectively prevented proper transcription. But certainly to the best of our knowledge, there were no submissions in respect of the 8 additional witnesses now taken in the skeleton argument. Just rounding this exercise off, there are statements for the purpose of CPR 52, paragraph 19, for the purpose of this appeal. They're in the core bundle for both Mr. Seiler and Mrs. Whitestone at tabs 9 and 10. There are references to the cost decision, paragraphs 119, 121, 123, but those again only concern the 4 key individuals. So pulling the threads together, we effectively say wasn't part of the cost decision, and that's unsurprising because it wasn't part of the cost application.
Yes.
Nonetheless, to be clear, insofar as the court is not with us on the main point of principle, insofar as the court's not perturbed by the fact that the allegations, for example, have come late in the day and are new on the appeal, and in particular, insofar as the court is willing to engage in the broad evaluative exercise encouraged by Mrs. Whitestone's representatives, the authority firmly rejects the characterisation of its conduct vis-a-vis the additional witnesses as unreasonable. I absolutely don't propose to take you through all of them, but to just give you one example, Mr. Gerber. Mr. Gerber was the chief executive of JBI.
But we've got no finding by the Upper Tribunal. A failure to call those witnesses was unreasonable. We're only here to decide questions of law, and I don't see at the moment how we could form a value judgment on whether the decision to call these additional, not to call these additional potential witnesses was or wasn't unreasonable, which on the face of it is a pure question of fact.
I needn't trouble you further on that issue, and I'm grateful. Those are my submissions.
I have one final point, which arises out of an observation my lord made and has been made against me in the skeletons about are we changing our case in the way that we're putting it. And in my respectful submission, whilst matters have developed, that would be unfair. And I give you 4 references, beginning with my or our skeleton argument for the purposes of the cost application itself, which is at supplementary bundle tab 22, page 146. And it's right to say, of course, the main focus of the cost hearing was on the was it reasonable to bring the case at all,
Yes.
which we succeeded on, but we did have a section on the approach to calling witnesses. And in particular, we say this at paragraph 73.1 in page 146. The first of the witnesses that we brought, whilst the tribunal, and I'm looking here at the top of 147, whilst the tribunal ultimately did not consider that all potentially relevant witness evidence was before it, It cannot be said that the authority had advanced a case which it should know could not succeed or failed to produce evidence to support its case. The authority was entitled to consider that there was a reasonable prospect of successfully defending the applicant's references on the witness evidence of Mr. Neary, Mr. Bates and Mr. Porter alone. Its case was properly brought. So our point, and our first point, has always been, yes, it might be that not all potentially relevant witnesses were there, but we are entitled to proceed on the basis of this case. This is the evidence we want to rely on the case that we brought. And so that was always our point, as it were, my lord. You've seen what's said in the cost decision.
If you'll allow me to say so, it doesn't appear with quite the clarity that your submissions this morning.
I accept that entirely, my lord, but it has somewhat developed through all parties, and there's no criticism for that. But we then put in the grounds of appeal at page, which one sees at page 17. And you'll see at
This is court
Yeah.
17.
Course 17, I'm grateful, tab 1. So paragraph 3, ground 1, so wrong in law, line 3, contingent on a false premise, namely that the authority is effectively required to exhaust all options to obtain evidence from any person that might reasonably be considered able to give relevant evidence to the
That's
tribunal.
not the same as the point you're making now.
Well, my lord,
You put it in ground 3 as required to exhaust all options.
in both grounds, exactly,
No,
paragraph 3 and
but
paragraph
your
7.
point now is that you're not actually required to exhaust any options. You can just choose what evidence you wish to place before the upper tribunal. It's up to you. There's nothing more you need to do. This is like civil proceedings, and if you fail to prove that your injuries were caused by somebody's negligence, well, bad luck. There's somebody who you could have put.
My lord, yes, but in terms of the way that we are putting it, we are obviously addressing in the grounds of appeal where what we consider the tribunal has found, and that's what we consider they have found. Now, it may be that, as it were, that we don't need to go that far and to show that's what they did, but that's what we believed they had done, and you've seen how it arose. But we were, and I hope you'll have seen, we entirely accept what the tribunal itself then said in refusing permission to appeal at pages 107 and 109. No. That's not what I was saying in terms of it. What I was saying is, and we've looked at it a number of times, the supervisory nature of the tribunal's jurisdiction and the key difference proceedings, and that leads to a skeleton argument that takes the points about friendship at paragraphs 36 to 37, and perhaps more emphasis today on that point than would have been hitherto. But it does come out of the tribunal saying, and my lord has rightly said, everyone is saying you're wrong to say this is the point, you're required to exhaust all options. The tribunal said, no, that's not our point. Our point is it's the nature of the proceedings. It's that distinction. It's because of that you had to call all these people and you had to answer the request for further information. But we've been saying the substantive thing right the way through, which was we don't need, even if there are people who are potentially relevant, we were entitled to do this. And that's what we said before in the cost hearing. But our particular target of attack being this jurisprudential distinction in the nature of the proceedings is one very much responsive, and in my submission, legitimately responsive to what the judge has said was in his mind, and one in my submission the Court of Appeal should consider and form a judgment on. May I just take instructions as to... Yeah, sorry, I am reminded of one point going back to the we've talked about Ms. Thompson-Beelman and the reasonableness of Mr. Courier, the two witnesses who were abroad. And I entirely accept there's a point about the characterisation of the judgment and how many factors were taken into account. But insofar as it is said you were unreasonable in the correspondence and in not taking it further, we do make the point, what are the tribunal, or could they suggest we could have done? You know, it said this correspondence is utterly feeble when we wrote to them, inviting them to come, but it's a fact we couldn't compel them to come. We couldn't mislead those witnesses. The only other thing we could have done is issue a letter of request, go through the international cooperation matters, but that is something this tribunal in the financial services context had never done before. It's obviously, to say that is required in every such case is quite...
It had identified its jurisdiction before.
Yes, in Ford, and we, yes. And again, I've made the point, it's unreasonable when there was no application for request for further information, no application for disclosure, no warning, if you like. We didn't know that we were required when we had a witness that we didn't believe was true, like Mr. Cambiano, to bring that to a directions hearing. The same point, and it goes to the unreasonableness point. If this was unprecedented, that is a factor that goes to whether we can really be said to have met the high hurdle of unreasonableness that no one had ever actually applied for or obtained a letter of request from this tribunal before. But subject to that point, then those are my submissions, or our submissions, my lord,
Yes,
my lady.
thank you very much. Yes, Ms. Clark.
Lord, I'm conscious of time. Do you want me to make a start in the 7 minutes that we have?
Which
I'm
would you
entirely in your
prefer?
hands. Well, I'm happy to make a start if you're...
Well, let's make a start then.
Right, then I will. Can you just give me a moment to slightly reorganise my arrangements? So, my lord, my lady, put simply, our submission is this. The appellant has not and cannot establish that the decision to award costs in relation to ground one, which is of course the ground that concerns my client, was wrong. Because the decision does not, and the appellant cannot establish that it does not, disclose some error of principle so as to make it wrong in law, and nor, secondly, can the appellant establish that the decision was irrational on the basis, as I understand their case, that it is a decision that was not reasonably open to the tribunal. Now, of course, it's important for the authority to shoehorn its case into one or other of those, or both, because of the restricted nature of appellate proceedings from tribunal matters in financial services cases to this tribunal, which are restricted to points of law. Despite that, as the court observed, and as is apparent from the submissions, a fairly large amount of the submissions that we heard go instead to factual matters, either primary findings of fact or inferences or conclusions drawn from various factual matters, as indeed the tribunal is required to do when considering a costs application. And I won't give you a lecture on the law of that, because you've A, already had one, but B, one of the areas where there is, as I see it, agreement between the parties is what the general principles are in relation to the making of a costs order. And it requires 3 steps. Firstly, the decision as to whether the authority has acted unreasonably in conducting the proceedings. I know that 10.3d is slightly wider than that, but what we're really talking about here is conducting the proceedings. And that is, as the case law makes clear, a value judgment, i.e. a judgment where you weigh up various factors and arrive at a decision whether something is reasonable or unreasonable. So it's not a primary finding of fact, but it is an interpretation of facts on a value judgment basis. Then, of course, it's a judicial discretion as to whether to make a costs order, and I'll come back to that later, and if so, to then determine the quantum. Now, all of my learned friend's submissions, as I understand it, both on paper and today, relate only to the first of those steps, i.e. the value judgment that the tribunal judge made that the authority had acted unreasonably. And so I focus my response on that. And we submit that there are 4 key reasons why the appellant has failed to satisfy you that this is either a wrong in law issue or an irrationality issue, and they are these. Firstly, a value judgment made by a judge with possibly unrivaled expertise in financial services enforcement litigation, given that prior to his lengthy tribunal career, he was in fact the chair of the FCA's Regulatory Decisions Committee, who presided over a lengthy trial and wrote a 199-page judgment and then a lengthy cost judgment, demonstrating that he carefully weighed up relevant factors and made a multifactorial assessment taking into account all relevant factors. In short, context is important. And in this regard, I refer to factual context. So that's point one in summary. Point two is the legal context in which the cost decision was made. And by this, I refer to the financial services Euro case, and I will come back to this in detail, but I'm just hitting the headlines for current purposes, bearing in mind it's now 2 minutes to 12, is that it is a specific ground as enumerated in that case that one of the bases for a finding of unreasonable conduct is when a party fails to produce evidence to support its case. And also, of course, the previous decisions of Frensham and Forsyth and the nature of the tribunal's role. So we submit that the authority are wrong in terms of their attempt to move away from the decisions, in particular Frensham and Forsyth.
Well, speaking purely for myself, that seems to be the most important point in your view.
I respectfully agree. Can I then hit the headlines of my remaining two? The third one is that the decision was based on particular facts and circumstances, and it's notoriously difficult to attack a value judgment, and even more difficult to attack a discretion.
Yeah.
And the case law, there's an enormous amount of case law on that, of which we have one or two examples in the bundle. My last point, I don't think will trouble the court at all, which is as regards the exercise of a discretion to award costs where there has been a finding of unreasonable conduct. The authority does not appear to be seeking to argue that if there is a finding of unreasonableness based on any or all of the matters that were found, that the exercise of a discretion to award costs, or for that matter the quantum, was unreasonable.
Yeah.
So therefore it seems to me it's only 1 to 3 that I need to trouble you with, and I completely accept, and from what I have heard this morning, that it's going to be the legal context that you're probably likely to be most interested in. May I
Yes,
stop
well,
there?
that's very well timed, Ms. Clark. Thank you very much. 2 o'clock.
Court rise in favour.
If you'd ever asked me, I would have told you that I'm not trying to say that all those other witnesses had a finding of unreasonableness. I'm trying to say this is the context in which they were entitled to consider you having produced witnesses.
I needed the 10 minutes to work.